Now, the President has yet to sign the Eighth Amendment to the Constitution, and it awaits his signature before it becomes part of Bunruch na hÉireann. It will read as follows: that the state acknowledges the right to life of the unborn and with due regard to the equal right to life of the mother, guarantees in its law to respect and so far as practicable by its laws to defend and to vindicate that right. They are the words that were before you, and you voted 2-1. I'm joined first by two constitutional lawyers, William Binchy for Plack and Mary Robinson, constitutional lawyer, who has been against this amendment throughout. Now, Mary Robinson, surely some of your speakers who have said this is a moral victory can scarcely be credible. It is an exact 2-1 ratio, a decisive result, surely.
I think that the result will be analysed closely over the next few weeks and will show that throughout the country, in every county in the country, there were people who went out to vote against this amendment because they had reflected very seriously on the issues involved. And in County Louth and in Donegal and in Mayo and in Kerry, I think that it is very encouraging to see that just because of the nature of the campaign and of the very substantial endorsement of a yes vote by the Catholic Church, that was not enough anymore in Ireland. There are people who think things through for themselves and who are prepared to say, no, I will not support this amendment for a variety of political, legal and social reasons.
But it is a defeat, surely, for yourself.
Yes, and I think not an unpredictable one. I mean, if it was unpredictable, then I would come in here and say I'm very disappointed. What I find is great encouragement.
But you wouldn't say moral victory, would you?
I would say that the result shows a considerable maturity and willingness by a broad range of people of quite conservative views on the issue of abortion, because I have always maintained, and I think it has to be maintained, that this has not been a simple vote for or against abortion. And I think that has come through, particularly in the Dublin area, particularly in constituencies where sides of the issue have been put.
William Binchy,
it's notable that in areas where the debate has not had a balanced two-sidedness to it, this is reflected in the voting, and that I think is certainly true in certain rural areas.
William Binchy, you were one of those who initiated this, but before that, just shortly before that, you talked about the implications and possibilities of having such an amendment, and you said the possibility might arise that you would bring on your heads a nasty emotive battle from which you might emerge with a less than impressive result, your cause having been constantly branded as anti-women, uncaring, doctrinaire and sectarian. Isn't that really, despite your 2-1 victory, pretty well where you are now?
Well, no, John, I'm very pleased with the result. And in fact, I share with Mary her view that this reflects well on the Irish people. The good thing about this debate is that it has been conducted for quite a considerable time. For well over 2 years, this issue of the referendum has been debated. And specifically for the last 6 months or so, the issue has been debated in considerable detail by the Irish people through all the media and through the normal means of communication. And I think it's fair to say that the judgment that was passed today, the significant majority in favour of the human rights measure that was passed today, is a judgment that was not taken hastily, but a judgment that was taken after due consideration of the argument in favour of the amendment and the argument against.
But is this where you wanted it to end up, as it were, in the long, looking at the long thing? I can see how you're satisfied with the result, given where you were, say, a fortnight ago, in the short run of this referendum. But looking at the 2 or 3 year, in setting out on this road, is this the sort of result you wanted?
Very much so. I must say, of course, one doesn't plan exactly how long a debate on this particular issue would take, but I very much welcome the fact that this amendment has taken place after extended debate, so that the charge cannot be made that this amendment was rushed through without due consideration.
Does Plack stay in existence now?
No, I read Julia Vaughan's statement today, which of course is the situation that once the amendment was passed, Plack ceases to exist, and this
Might
is the
there
case.
be test cases, though, on this, do you think?
Well, certainly all I can say on this issue is that I think it's been fair to say that for the last 6 months, the spectre of women's life being at risk by reason of test cases being taken to the court, this has been raised, and I'm glad to say that the people, having considered that particular argument, have manifestly rejected it by their vote today.
Mary Robinson,
may I just say one more point, John, on that? I say that, of course, the courts are open to everybody. Mary, if you recall, took a case on behalf of a client against the holding of this referendum, but the result was that she lost that case because the court considered the issues involved. Similarly, in the area of women's health, if some crackpot were to take a case in this particular area, the court would dispose of the case with no difficulty whatsoever.
Mary Robinson, do you think there will be test cases?
I must say I don't like the use of words like crackpot. We're talking about very serious issues, and I, together with a lot of lawyers, the majority of lawyers in this country, raised the serious difficulties that are implicit in the ambiguous and complex wording of this amendment. Yes, the people went out and voted yesterday and we counted the votes today, but what we're faced with now is a legal section in the Constitution. And all I can do, conscientiously and fairly and honestly as a lawyer, is try to assess the implications of it. It is very ambiguous. Even the concept of the word unborn is not known to lawyers. Therefore, it must be determined. The effect on contraception in this country is, I think, worrying a lot of people, and I can understand that worry.
Do you think there might be test cases on that?
I think that if certain types of contraceptive devices which are available at the moment are the IUD, the certain types of pill are no longer legally available in the country, and there's some doubt, and I think serious doubt, about the IUD even under its present status. And if that is affected, as it could certainly potentially be by the wording of this amendment, and either civil action is taken or criminal prosecution is brought, then of course it will be tested before the courts in this country.
If it went to the Supreme Court, couldn't it be that the Supreme Court, in examining the issue, would take into account the intention of the electorate, which is fairly clear, and the intention of those who in the legislature who've been putting it forward?
No, the Supreme Court would be concerned about the text of the wording and of construing that, merely the text of the wording and construing that text. And the words are not easy to construe. Anybody who says facilely or said in the course of the referendum campaign, it's absolutely clear. And
John Kelly said it would be absurd, for instance, to think that the Supreme Court could have any difficulty in construing
Well, the first problem that the Supreme Court could be faced with is the problem of defining when the life of the unborn begins. Is it at the time of fertilization? If that is so, do certain types of contraceptives, the IUD for example, prevent implantation? That would be an interference with what we have now regarded as a constitutional right to life of the fertilised ovum.
William Binchy.
That would have very substantial implications.
I think we should get the discussion into perspective. The amendment that was passed by the people substantially today was an amendment to protect the unborn against abortion. The amendment does this, and the amendment
your construction of it.
Well, may I just hold on 1 second? The amendment does this, and the amendment ensures, for instance, that our law will be protected against the possibility of a strong pressure being brought in this country as a result of a European decision which would be pro-abortion. I must say in this context that Mary has objected to the amendment precisely on the ground that we would be bad Europeans in failing to comply with a European decision from the European Court in favour of abortion. I would say in this particular context that the issue of the human rights of the unborn against abortion is of such a nature that we should make up our own mind on this matter and not particularly worry in this context whether a European court would favour liberal abortion or not.
After the debate on the referendum and so on, another of the issues that you go into in great detail, theoretically admittedly, in this chapter in this particular book, is whether, for instance, women who now leave the country at the rate of 10 a day should be prosecuted for having abortions abroad. You theoretically examine that in great detail.
This is true, John. I examined it in the context of the previously existing law prior to the passing of the amendment. I should say in this context, you mentioned Professor John Kelly, the foremost constitutional lawyer in this country, and he used perhaps an indelicate expression to describe that type of argument. But what he actually said on last Saturday's radio programme was to assert that the Supreme Court in those circumstances would grant an injunction against a woman going to England was to assert that the Supreme Court was composed of imbeciles.
Well, what about, for instance, referral agencies? What happens if a girl says, I intend to have an abortion? I've got the address of a backstreet abortionist in Britain, and somebody else says to her, here's an address of an abortion clinic. Can that person, if they give the advice in this country, or if they're a clinic, could they be prosecuted?
No, they could not be prosecuted under existing law. This is quite clear, and the amendment doesn't affect statutory law in the country, and they could not be prosecuted
Do you think
once
they
the
should
amendment
be?
has gone through. No, I don't.
Mary Robinson.
I'm glad to have the opportunity of replying to some of the certainties that William Binchy is asserting here. I think as lawyers we have to be modest in what we know. We're faced with very complex and difficult provisions. We're now in a post-referendum situation, and I would like to get away from this misconstruction of the role of the European Court. It was an easy debating point to raise a scare that the European Court might force us to have an abortion law. In fact, the situation is both complex, difficult to answer in the brief time in a television programme, and nuanced in a way that William Binchy denied. The European Court Commission has been neutral in relation to abortion, has found that there is no right to choose under the Convention, and has also identified the right to life of pregnant women as being superior to the right to life of the unborn fetus, for the obvious reason that the right to life of the fetus is biologically dependent on the mother. And I think most medical practice would accept that in a life-threatening situation, the right of the mother is superior to the fetus. It is important that we in Ireland do not resent or build up some block about our European commitments in the area of human rights. They are important and they apply here.
William.
As far as the question of a possible application for an injunction is concerned, that is a real legal possibility now. We have created a right to life of the unborn. That right is entitled to its remedy. It's entitled to be asserted. It can't be asserted by the fetus for obvious reasons. It can be asserted by a third party.
William
This
Binchy.
is all possible legal litigation that we're facing into.
William
Well,
Binchy.
Mary, unfortunately, you are misstating and seriously misstating the situation with regard to the European Commission. The European Commission in the Payton case, which was decided in 1980, made it very clear that the liberalisation and the extension of abortion law in England was a factor which it took into account in deciding the degree of protection which the unborn should have against abortion. The advantage of the amendment which we have just enacted into our constitution is that it will protect us against that type of interpretation.
That is not correct. Can I just nail that? If you are correct about the European Court, this amendment does not prevent an action going to the Commission of Human Rights. I don't agree with your interpretation, but if you're right, this amendment makes no difference. We still have our commitment under the
Sorry, Mary,
Convention.
it's not a question of interpretation. I don't want to labour this point.
I'm
It's a
afraid
question
it
of
is.
fact. It's a
I'm
question
afraid-
of what the European Commission said, and the European Commission made it absolutely plain in its judgment.
You're very certain on all
well,
these
I'll show-
issues.
I'll show-
continue
I-
this
I think
debate
a lot
and-
of lawyers would
I-
be more
I'd like
modest
to
in
thank
their
both of
conclusion.
you.
I'll
I'd like
show
to
you
thank.
the passage after the...
Right,
I
I'd
know
like
the
to thank
passage and I
both
don't
of you,
agree with
and
you.
both of you may continue this debate in the learned journals with footnotes. Thank you. Brian.
So if you thought the lawyers would have it settled after the referendum, you're